Hey guys, welcome to today's Legal 101, being a mandate on employment and labor relations law. Now, today we're talking about probation and underperformance, and we're borrowing from a judgment by Lady Justice Nzei in 2022. Now, after each side had given their story, this is what the court deduced as being factual. That after completion of a 6 month probationary period, the employee, now in this case the claimant, continued to work for a full month before they knew the way forward. And after expiry of the month, they received a letter purporting to extend their probationary period for 3 months. Now, the contract that they had executed with the employer provided for extension of the probationary period at the discretion of the employer. First mistake. The employer, during the court hearing, of course, tried to say, oh, there was actually a consultation before the extension, it was oral, but you see that oral discussion was not captured in this letter extending the probationary period. Now, at the expiry of the extended period, the employee was summarily dismissed for poor performance and was paid in lieu of notice. According to them, their performance was at its optimum level. They were ranked number 15 in the whole county, so they did not understand why their dismissal was based on poor performance. And lastly, they said that in the 9 months they worked at the company, they did not receive house allowance. Now, this is what the court determined, that there was no consent obtained from the employee by the employer before extension of his probationary period, contrary to labor laws. I think I've mentioned this before, that as an employer, before you extend the probationary period, you must seek consent from the employee. And it should not, the entire probationary period should not extend 12 months. Okay? Then number two, the court said that there was no documented hearing to discuss the employee's performance, giving him an opportunity to defend himself. Therefore, the termination was procedurally unfair. I think I've also mentioned this before, that if it's gross misconduct, if it is underperformance, you as an employer, have the obligation to call this employee and get their side of things. The court also made reference to a Court of Appeal determination issued in 2019, where there was a breakdown of the obligations of an employer before terminating somebody on account of underperformance. And number one, the court said, as an employer, you must ask yourself, do we have an employment policy or practice on how to measure good performance versus poor performance? And you must ask yourself, number two, what measures have we put in place to enable us assess the performance of each employee, and what measures have we undertaken to address the said poor performance? Number three, you must ask yourself, beyond having such an evaluation measure and before termination, did we call the employee, explain our grievances, and allow them defend themselves or address their weaknesses? And number four, you must ask yourself, as soon as we decided to terminate them, did we call them again in the presence of another employee of their choice, giving them the reasons? Other than that, the whole procedure will be considered unfair. So in the end, the employee was awarded compensation for unfair termination, which was 8 months salary. The maximum, I think I've mentioned this before, is 12 months salary. And the court also said that their claim on house allowance was valid because the employment contract did not state that the salary they were receiving was consolidated. So it was calculated at 15% of their monthly salary for the 9 months that they were in employment. And lastly, they were awarded costs of the suit, but also something to be aware of. The employer was informed that this amount that they were supposed to pay was subject to statutory deductions, pay, NHIF at the time, NSSF, that the employer was supposed to deduct these amounts and remit them accordingly. Okay, so that marks the end of today's Legal 101. I think by now you have seen a theme in the Legal 101s I have posted on employment and labor relations law. One, it's about what the contract provides. Two, it's about the policies in the organization. Three, it's about procedures on termination. Four, it's about how you treat people while they are with you. It's always to make sure as an employer that you are compliant. These things are not, there's nothing new under the sun. Just consult as much as you can before making a decision. And as an employee also, you need to be aware of your strengths. You need to be aware of when to stop kicking, and when you are wrong, you need to be aware of that as well, and ways in which you can mitigate. So that is basically what it is about employer-employee relationships. Something that I keep saying, it is not a slave master relationship. It's supposed to be a 50-50 relationship where I am giving and you're giving. That's the ideal situation. But most times I think we feel that employer-employee relationships are similar to master-slave relationships where we don't feel like we have a voice. But we do. And as an employer, you can only do so much, or you can only push the boundaries so much in staying non-compliant. One day it will just blow up in your face, and you don't have money to be paying for lawsuits such as this, including costs. You don't have the time to be in court. You don't have the time to play with your brand like that, because I can imagine what it takes to actually build as an employer. Okay, this money could be put to better use if you just remain compliant. Okay, so that marks the end of today's Legal 101. See you tomorrow for tax law.